On today's episode, we're going to cover some of the common agreements and contracts that you should expect to receive from a real estate agent if you're buying and selling property. Okay? I just want to start at the onset by saying that I am not a real estate attorney and take all the things that I'm going to say today with a grain of salt. I'm only speaking from personal experience and I'm only talking about things that have applied to me. Okay? I am not an attorney, so take that to the bank. With that being said, if you decide to buy or sell real estate and there is an agent involved, regardless, they are going to make you, in order to deal with their seller, their buyer, whoever they're representing, they're going to make you fill out a bunch of paperwork. Okay? And, excuse me, one of the most common that you're going this is a common contract that you're going to receive, and that's the agreement slash contract to buy and sell real estate. It's a purchase agreement or it's a real estate contract. However you want to line it out. This contract, when I do a contract and I'm working with the buyer or the seller directly, I got a 2-page contract. This really straightforward. Hey, I promise to sell you the property as long as you promise to buy it from me. I'm going to sell it in the condition that it's in. I'll make sure the taxes are paid. But outside of that, I'm not making a ton of guarantees. If there's a lien on the property, that all kind of is discovered when the real estate agent does, or I'm sorry, when the real estate attorney does the title work. And if problems like that do occur, then we fix them at that point. Okay, there's a lien on the property. It's going to cost 10 grand. I'm not going to spend that. Do you want to spend it? And you kind of just got to be in communication. And that's something that I think folks forget is it's always better to be in communication with the seller, be in communication with the buyer. You do not need an adversarial relationship with these folks. There's no reason to have that. You want to make it you want to make sure that the communication stream is a healthy one. It's open. You can call them, they can call you, they can ask questions. Hey, I want to be clear on certain, these certain things about the property. Is that how you understand it? So as long as you have an open stream of communication with the seller, with the buyer, you're going to be in a good place. It's when you have that adversarial relationship, when your approach to negotiation is one of, it's your approach is, I need to win and you need to lose, or you need to lose in order for me to win, and vice versa. If they're trying to ensure that you lose so they win, when you have that adversarial type of relationship, it makes the process cumbersome. It makes it a burden. You're not happy. It's unhealthy. Really, the approach for these type of negotiations is we want win-win outcomes. So, and you have to approach it that way. I want, as close to the asking as possible. And if you give me the asking, I'm willing to be flexible on these couple different things, and vice versa. If they're like, hey, I'm gonna offer you less in the asking, but I'm willing to close faster, or I'm willing to do certain things that are gonna put stuff in your bucket. And so you want to look at the negotiation process as a win-win from the onset. I'm going to give some, you need to give some, okay? And we're both going to come to the table and we're going to make compromises in order to make this work. I think that's the best approach to negotiation, because you end up being, there's no animosity at the closing table. You're not looking at the buyer or the seller, and you're not thinking, wow, that guy's an asshole. right? You don't want that feeling. You don't want to go there. You want it to be you want there to be mutual respect, where you say, hey, thank you for working with me, and they're like, hey, it was a pleasure, thanks for working with me. And that's kind of what you're aiming for. All right, but when you've got agents in the mix, they're going to give you contracts that are 9 pages long and several different disclosures and different agreements, just because a real estate agent, you gotta understand, they're coming in as a third party, and they don't want to be liable for anything that happens at the property. If you have a fallout with the seller, with the buyer, they don't want to be involved in the repercussions that come from fraud, or from someone misleading, or someone not being truthful and honest. For example, if you say, hey, my house is 2,000 square feet, and you're selling that house, and you're saying, hey, it's 2,000 square feet, and you're putting it on the listing, and the agent does that, and the buyer buys it, assuming that, hey, the house is 2,000 square feet. Well, if it comes to find out that the house is actually 1,800 square feet or 1,900 square feet, well, they've got grounds to now take you to, they can take you to court. They can sue you for misrepresentation. They can say, hey, you lied about the property. And so there's a lot of particulars there, right? Does it happen? Yeah, it happens. But I don't know that it's as prevalent as you would think it is, right? So you just want to be honest, and you want to be straightforward and truthful in these things. All right, and an attorney doesn't want to get in that mix, so they're gonna make you fill out all these contracts. But we're gonna go through these contracts, and like I said, I'm not an attorney, but just kind of talk about the different parts. All right, so paragraph 1 of the agreement / contract to buy and sell real estate, residential real estate. All right, part 1 is the parties, so who's involved, and you've got here the buyer and the seller. In this case, the buyer is an individual, and the seller is a corporation or a limited liability company. Okay? Pretty straightforward. You've got a disclosure here where you have to check off whether the buyer or the seller is a South Carolina real estate licensee. So in this case, neither the buyer or the seller has a real estate license, and so they don't have to disclose it. Here we have another acknowledgement. This is saying that the buyer acknowledges receipt of the South Carolina disclosure of brokerage relationship form, and it's receiving client customer service in this transaction. And the seller did not, or is also acknowledging having received it, but there is no client or no representation in this case. All right, part 2 is the purchase price. So this is, again, just kind of basic. So the purchase price in this case is $29,000, $29,500. And then here, is how are the funds going to be transferred? So is there financing involved in this deal? Is there a combination of financing and cash? Is it straight cash? Is there verification of cash available for closing? In this case, it says that it is attached or not attached, or to be delivered on a certain date. And then, here you can specify whether the contract is or is not contingent upon the sale and closing of buyer's real property. And a SCR 504 is not attached. So I personally don't know what this is. South Carolina SCR 504. I'm not sure what it is. In this case here, the sale is not contingent upon the sale and closing of the buyer's real property. So there might be situations in which you own a house and you plan on selling that house in order to move to another house, and so when you're making offers for your new house, you make the offer contingent on the sale of your current home. And these are one of these areas where you can say, hey, I'll pay you more for your property, but I want to make it contingent on me selling my house. Or the seller might say, look, I'll sell it to you for less, but it can't, I don't want it to be contingent on another sale. Okay, so this is where you can start negotiating these type of things. All right, number 3 is the property. So this is basically, you're putting in the information of where the property is located. So the address, the city, the zip code, the lot block, and the subdivision, other lot 19 section 2, and then the tax map. Again, my opinion and what I do when I'm filling out these contracts, what I do is I usually just put the county and I put the tax map. So the county the property's located in and the tax map, and that's usually sufficient for a real estate attorney to look up the property and find, hey, specifically, is this the property that you're trying to sell? There's some other language on here. So this is, hereby acknowledging sufficient good contract consideration. And considerations is another word for, something of value that's being given, whether it be escrow, money, cash, a car, could be consideration. Something that's got some kind of monetary value to the seller. Seller will sell and convey to the buyer, and seller will sell and convey, and buyer will buy for the purchase price, any and all of the lot of land. So this is saying like, hey, I'm promising to sell it to the buyer, and the buyer is promising to sell it from me. Okay, seller agrees to maintain in operable condition the property and any personal property conveying in the same operable condition. So this is like, this language, what this kind of piece is saying is, hey, as a seller, you have an obligation to maintain the condition of the property. Because it wouldn't be fair for me to come, one day to the property, look at it, and it looks great. And then the day of closing, come to the property and, there's holes in the wall and the roof is collapsed and the house is just in terrible condition, right? I wouldn't be obligated as a buyer to purchase it in that case because you did not keep your end of the bargain. You have not maintained the condition of the property. And this, it looks like it extends to landscaping and grounds and any agreed upon repairs and replacements from the effective date through closing. Okay. All right, number 4 is conveyance and closing possession. So this is, you're basically saying, hey, we're going to close the property on this date. And you're going to, we're going to transfer a general warranty deed free of encumbrances and liens and in the name of this person. Okay? So a different person, so you could have one buyer, the buyer here, and the buyer can convey the deed in another name. So maybe for like a child, right? So if she wanted the deed of this house in the name of her child, she can specify that here by just placing the name of the child or the friend or of the relative or whatever the case may be. Step 5 here is the earnest money. So you see here they put $1,000 in escrow and they sent it in the form of check. You can send it in the form of cash or other. So for example, a wire. And the escrow was sent to this attorney right here, Norwood, Armstrong, and Stokes. So here's just kind of an agreement that the parties understand, agree that under all circumstances, including default, escrow agent will not disperse any earnest money deposit to either party until both parties have executed an agreement authorizing the disbursement. So I've been burnt by this before, where I was going to purchase a property and I sent the money to the real estate agent and then the seller just disappeared. And nobody can get them to sign anything or it was like they went ghost. And so I couldn't get my money back from the real estate attorney. They kept it in escrow because they did not have authorization from the seller. They need authorization from both the buyer and the seller before they disperse it. So they both. So as a seller, I have this. If the money's going to go to the buyer because I defaulted, I need to fill out a paper. I need to sign a form that says, yeah, you can go ahead and disperse it to them. I messed up, and vice versa. So in my case, I actually had to sue. I hired an attorney and I sued these folks so that I could retain the property. All right, step 6, you got transaction costs. Step 7 is financing. In this case, it wasn't contingent upon financing. Repairs. I sold this property as is, so I would recommend that. And it says here, if no boxes are checked, this contract will be an as-is contract in regards to repairs. So if it's an as-is, it's you're saying, hey, I am selling the property in the condition that it's in, as-is condition. I'll keep it in the condition that it's currently in, but I'm not doing anything extra above and beyond to get in any type of better condition. There are certain situations where you won't do an as-is contract, and if you're selling a house, it's in good condition, well maintained, and FHA, and there's the inspector goes by and they see some kind of a minor issue or infraction on the property, then the FHA lender will ask for those repairs to be made in order to qualify for financing. That wasn't the case here. Due diligence is just saying, hey, we're going to give the buyer a due diligence period where they do all their research. They can hire inspectors, they can get an appraisal, and they've got onto a certain date, right, to do all those things. Inspections and inspection rights. So here it's saying that the buyer and a South Carolina licensed and insured inspector is reasonably perform any reasonable, ultimately non-destructible examinations, giving them permission to go into the property and do an inspection, and that issues related to the property at buyer, so including investigations of off-site conditions and any issues related to the property at buyer's expense. So the buyer, it's saying basically you can hire an inspector. It's going to be at your cost, and the buyer and that person can then make any reasonable visual observations. Here's just saying kind of, hey, the seller agrees to make the property accessible for that inspection and not withhold access. And then here's just a check mark saying that the seller, in this case it was me, granting the buyer permission to connect utilities, pay for utilities, and hire professionals to safely connect and operate the utilities during the inspection. So this is like, hey, if you need the water running, the light running, if you need all these utilities up and running because they're off, this would give the buyer permission to take the contract, go to the electrical, to the energy company and say, hey, I need the electricity on for 30 days so I can do an inspection. So that's pretty neat. So you can do that. All right, here, this is a disclosure here that is just, this is a real estate agent kind of disclosure. Buyer will hold harmless, indemnify, pay damages and attorney fees to seller and brokers for all claims, injuries, and damages arising out of the exercise of these inspection rights. Seller will hold harmless, indemnify, pay damages and attorney fees to brokers for all claims, injuries, and damages arising out of the exercise of these inspection rights. Broker recommends that parties obtain all inspections as soon as possible. Brokers recommend the parties and inspectors use insurance to manage risk. I have no idea. I have no idea. No idea. But, this is language that they want to put in because it makes them feel better. All right, appraise the value. So some contracts are contingent on the appraised value, which means that if you got a house and you put an offer for $500,000 and it comes back appraised at $300,000, if you have this box checked here, this gives you an out. You can say, hey, I no longer want to purchases property. In this case, the contract is not contingent upon the property being valued at an appraised value. So this is regardless. If you put a $500,000 offer and the house came back appraised at 50 grand, you're going to still buy it at 500,000. Wood infestation report, so you can hire an inspector to go and look for termites. In this case, the contract is not contingent upon it. You got survey, title, examination, elevation, insurance, survival. So this is kind of like if any provision herein contained, which is so like if you die, whoever inherits the property is obligated to sell it to you. Home warranty company, operational coverage. You got fire and casualty or injury. You got a South Carolina residential property disclosure statement. And I had to do this disclaimer, and I basically just put, I don't know, for everything. Because it asks you, like, what's the condition of the roof? I just put, I don't know. What's the condition of the floors? I don't know. I don't know. I don't know. All across the board. And I didn't know for this house. You got lead-based paint and lead hazards. So if the house was built before 1978, there needs to be a lead-based paint and lead hazards kind of disclaimer. Sex offender criminal information. So parties agree that brokers are not responsible for obtaining and disclosing information. So this is like saying, hey, if you got a pedophile next door, the broker's not obligated to do that research, and even if they know, they're probably not obligated to tell you. 19, trust account, interest, charitable contribution. It is understood the broker may place deposited earnest monies into an interest-bearing account. If buyer's earnest money deposits is deposited into an interest-bearing trust account, parties agree that the broker will retain all interest earned in said account and may contribute some or all to a charitable expense. It's just outrageous. So they can put your money into an interest-bearing account and then not give you the interest on that money. Is scandalous. That interest is yours, bro. All right. 20, South Carolina income tax and non-resident gain and compliance. I have no idea. 21, entire and binding agreement merger clause. I don't know. Adjustments. You got in the case of default, so this here specifies if seller defaults in the performance of any of their obligations in this contract, buyer may deliver notice of default, pursue any remedy available, recover attorney fees and all other direct costs, and you have other remedies here if the buyer defaults. Mediation is kind of saying, hey, if we do come to differences, here are the steps we will take to mediate, whether it's find a mediator or some kind of other alternative dispute resolution. And then, you got more disclaimers, broker compensation. So this is, hey, parties directly closing attorney to use settlement funds to collect and disperse to brokers. So it's saying you're going to pay the broker directly from the closing. Attachments and other contingencies. So there's none here. Notice and delivery. I mean, this contract goes on and on and on. Here's one thing that there should be, and I didn't catch it. So when signed by a party and intended as an offer or a counteroffer, this document represents an offer and it expires at. So you're supposed to put a certain time, so 12 p.m., for example, on, October 31st. You have until then to accept my offer or decline my offer, but I need a response. Otherwise, the contract's going to be null and void. And then here comes the signature. So you have the signature of the buyer. And this was all signed online using DocuSign. And then my signature as the seller and my initials. And then you've got the buyer's agent. So this was the buyer's agent, Danielle Zambrano. And he worked at DZ Pro Realty. And that's his license number. email, and phone number, and then Christy Morbaugh. And she works for eXp Realty LLC. Doesn't have her office code, her email, and her phone number. And that's a contract. It's crazy. Crazy contract. Another disclosure here, so compensation agreement. So this is a legally binding compensation agreement. So parties agree that the seller agrees to compensate the brokerage company for the purpose of buying the property information again, and then the terms, and then the compensation shall be paid in US dollars according to the following terms. A compensation amount of, you're usually typically here for compensation working with a real estate agent, it's going to be a percentage. If the buyer is simply representing the if the agent is simply representing the buyer, it's typical for them to get a 3% commission. If they're representing both the buyer and the seller, then they'd get 6% commission. In this case, the house, I want to say, was less than $29,000. So considering that, a commission on a $30,000 property is going to be, it's not a lot of money. It might be $1,200, or whatever it is. So what I did, because I wanted to sell the property, I put out there that I'll pay, a buyer's agent $2,000, which is way more than 6%, but I'll pay $2,000 if you bring me a buyer. And that's how I locked up this deal. I ended up paying, agreeing to pay the buyer's agent $2,000 to bring me a seller. Because look, buyer agents are not going to bring you buyers for free. They don't do this stuff pro bono. They are technically supposed to serve the best interests of the buyer, and if they find a really great deal, you would think, hey, the best interest to the buyers, you present them the deal. But that's not the case. They don't always do that, right? They're looking for a commission. They're going to present the buyers, because they're the gatekeepers. They're going to present the buyers as gatekeepers. They're going to present the buyers the deal that's going to make them the most amount of money, them being the agent, right? And then finally, here is a disclosure of information on lead-based paint and lead-based paint hazards. So maybe the house was, older, from 1978. But this is basically saying, hey, seller has no reports or records pertaining to lead-based paint or lead-based paint hazards in the housing. Seller has no knowledge of lead-based paint or lead-based paint hazards in the housing. And then this is my agent's signatures, and then my signature and the agent as well. And that's it. It's a lot of signing. Honestly, there might be more disclosures that came with this deal that I just don't remember. This is kind of the files that I kept. But agents make it tricky. They really do. They make it tricky. They're gonna inundate you with a bunch of agreements. And what I find is that, when you overcomplicate things, when you've got all these agreements, this is what makes people hesitant. This is what makes people confused. Because you see all these agreements and you think, oh my God, I would have never thought of filling out all this paperwork. But you really don't need all of this paperwork. This stuff happens because as buyers and as sellers, we allow these agents, who a lot of them, you just need a high school education, really, or a GED. We allow these guys and these girls to negotiate on our behalf, and they're not trained negotiators. And then, they negotiate and they do something that like what I was saying earlier, they don't treat it as a win-win type of situation. It's a win-lose in their mind. They need to win and the other person needs to lose. And that creates tension and animosity. And then, when you come to the closing table, you feel like the other person had one up to you or got something on you, and you immediately resort to an attorney to get even. And, real estate agents, they are a big part of that. They create that dynamic because they are not trained negotiators. These folks aren't going to school for negotiation. When they go to real estate school, it's whatever, 40 hours, whatever, however many hours that they need, and a lot of it is just statutory laws, how to fill out a contract. There's no negotiation practice. There's no negotiation training. These folks, a lot of them don't know how to negotiate. And I'm telling you, if you've got a good relationship with a buyer or seller, you could probably write a contract on a damn napkin. Hey, I'll pay you X amount. We close on X date. You pay the taxes and you sign it, whatever. You just have that. The reason why all this contract stuff came out, it used to just be, hey, word of mouth. Hey, man, I'll buy your property. And that was enough. And then you sealed the deal, right? Nowadays, you need all the paperwork and everything else just because it gets too convoluted sometimes. It's just you can't trust folks sometimes. But look, this is a big contract. You don't need this. In my opinion, you can do better with something much smaller, and it sets the tone for the relationship. Think about it. If you are buying a property and the seller sends you this, you can be like, okay, hold on. What does any of this mean? Right? This is all going to be foreign to you. Really, the important part is number one, who are the parties involved? Number two, obviously, the purchase price and how it's going to be paid. Number three is, hey, this is the property you're buying. Number four, this is when we're closing. If there's earnest money, fine. I really never put earnest money. And you don't need much more after that. You really don't. My advice is have open conversation with the buyer. Try and be as flexible as possible. Hopefully they're flexible as well. And maintain that good relationship. And shoot for win-win. If you shoot for win-win, it will not steer you wrong. Folks, I know it's a big contract, and like I said, I'm not an attorney. I'm not an expert in this stuff, but I hope you found this beneficial in some way. Again, if you don't want to deal with anything, if you're looking for money in 24 hours, 48 hours, if you need money tomorrow or over the weekend because whatever, you're in a jam, and you want to sell your property and you don't got time to go and Google a purchase contract. You don't have time to market the property, to find that right buyer. Reach out. You can visit our website, palmettolandbuyers.com. We buy real estate all over the state of South Carolina. We buy land. We will buy houses. We will buy mobile homes. We'll buy whatever you got. As long as it's real property, we will buy it. Okay? I'll figure it out. If it's landlocked property, I'll figure it out. Just call me. I'll make you an offer on it. If it's a water lot, if you got a lot, it's all water, call me. I'll make you an offer on it. I will make an offer on any property in South Carolina. I will do all the research. I will pay to have the deeds prepared. I will do everything. You don't have to lift a finger. All you have to do is open the envelope when you get a check from the attorney. Or if we meet in person, all you have to do is count the $100 bills when I pay you in cash. That's all you've got to do. All right. So if you're interested in that and you want to reach out, you can call me. My personal number, 803-201-9137. My name is Joe. And again, visit the website, palmettolandbuyers.com. You can visit us on Twitter, Facebook, all that stuff. palmettolandbuyers.com. Thank you, folks. I love you. We're here in South Carolina. Again, best state in the country. And I hope you guys enjoyed it. Thank you.